To your honors, once again, my sincere respect to the court. We are co-prosecutors in this case file, and I would like to respond to what the defense has addressed in the submissions and in this oral submission in this hearing. My co-lawyer will respond also at a later stage, and at the beginning I would like to respond to the co-lawyer, the national co-lawyer. First, what I have observed during this hearing, I've noticed that the defense has not addressed about the execution of the order of the co-investigating judges, and what the co-prosecutor is still in support of the adversarial hearings that are significantly reasonable, acceptable, because we refer to the rules and law, the national law and the rule which is about the discretion of the co-investigating judge in such a decision. And in the internal rules, as the co-lawyer already addressed in Article 41 to 43 in the internal rules, the co-prosecutor see that it is not really clear. But if you look at the criminal procedure code that has been enforced in Article 187, for example, how the warrant or orders are issued. In this regard, the co-investigating judges will issue the arrest warrant or arrest and detention order, and the wording and paragraph is very clear, and that the co-investigating judges has the discretion to do so. Mr. Lawyer said that the detention, the arrest warrant is only applied to the criminal act, and that there was not any arrest warrant at the very beginning. But in the proceedings, it does not state that the co-investigating judge should issue any which warrant first. But in Article 85 in this criminal procedural code, it states the term may. Of course, the term may is not obligatory. It means that the co-investigating judge may make a decision to choose any one warrant according to the discretion. This is the point that I would like to respond to the co-lawyer in regard to the Cambodian criminal procedural code. And again, as stated in the agreement, if there is no significant clearness of the rule as stated in the internal rules, then the other laws, relevant law, would be applied. And I would like to respond also to the national lawyer. And as he already pointed out, I would like to summarize the summary of the facts and who Nuon Chea is and why he was charged, or why he has been charged. And we will also touch upon the appeal by the national lawyer against the provisional detention order by the co-investigating judges, as he claimed that it violates the rights of his client. So this is the object of the appeal of the lawyer. I would like to share with the court that Nuon Chea was born in 1926 in Wat Kaw village, Battambang, and in 1940 he pursued his education in Bangkok, Thailand, and in 1950 he returned to the Communist Party of Indochina, including Vietnam, Laos, and Burma. And when Tu Samut was arrested, Pol Pot became the secretary of the Communist Party of Cambodia, while Nuon Chea remained as the deputy secretary of the party. So this is just the information to link to his charge. And later on, the Workers' Party, which later renamed to the Communist Party of Cambodia, with whose founders include Nuon Chea, Ieng Sary, and Sao Pham. And Nuon Chea, of course, was known as the brother number 2, and he was in the Central Committee and the Standing Committee of the CPK. Later on the 19th of April 1976, he was the president of the Standing Committee of the People's Assembly. And between September and October 1976, Nuon Chea became the acting prime minister. Nuon Chea was appointed by the party to be in charge of social affairs, culture, military, and formal education. Nuon Chea directed the domestic and international matters and acted as the intermediary between S21 and various zones. With the position and authority as the Deputy Secretary, the member of the Standing Committee, the charged person allegedly known as Brother Number 2, he was the architect and the policy implementer and behind the criminal policy, for example, the persecution, unlawful deportation or transfer, forced labor, unlawful confinement of a civilian, and also the causing of great suffering or serious injury to body and mentality, and torture and killing of many people during this period of almost 4 years. So with these arguments, with the result of the co-investigating judges, there has been well-founded evidence that this person have committed a severe crime as charged by in the introductory submission, and also as stated in the and the submission in response in paragraph 122 A to D, and in that introductory submission of the Office of Co-Prosecutor. And the charged person, after being sent to the co-investigating judge to conduct further investigation, the co-investigating judge issued a provisional detention order on 19th of September 2007, but the lawyer challenged that order and filed an appeal on the 12th of November 2007. The appealed points include: number 1, lawyer submits that the detention is in breach of his rights. And number 2, lawyer or the defense submit that this provisional submission does not satisfy as set out in Rule 63, and in point number 3 it is a suggestion by the defense that the charged person volunteers to stay at the detention facility, but there should be order of security assurance for him, but it is not an object of an appeal. I would like to elaborate on some other points, including the point raised by the defense that the detention of his client is a violation of his right. We co-prosecutors, as already submitted in our submission in response to the defense, we strongly support the provisional detention order by the co-investigating judge still. We find that this provisional detention order does not violate the charged person as claimed by the defense. The co-lawyers, we have examined the fundamental rights of the charged person. So, co-prosecutor, of course, have examined what the co-investigating judges have been doing. So these proceedings are not being violated. Because on the first day when the charged person appeared in the court, co-investigating judges have already informed the rights of the charged person at the very beginning during this initial appearance. And when during the adversarial hearings, the co-investigating judges, having considered the fundamental rights of the charged person, then has been asked by co-prosecutor to really assert these rights again, and but the charged person still would like to proceed this proceeding, and of course he would like the adversarial hearing to go on. So the prosecutor, of course, really taken into consideration all the fundamental rights of these charged person. And what addressed by the defense is consistent with what we have been considered, because the notification of the rights to the charged person is very important. And having been working at the local national court, we also paid so much attention to this also, because the rights of the accused or the charged person has already been in the written form, and it has been practiced in our national court also before the ECCC. And we know that the charged person deserve or has the right to counsel or to assistance, and the right to have significant time to defend, or the right to receive or to be tried within a reasonable time. And we also, of course, want to make sure that the trial is expeditious, so that of course we are not really making a decision on this, but we have the role to make sure that the proceedings are well followed. So this is, of course, our role. And we have the right to monitor these proceedings. So the fundamental rights, as I pointed earlier, as stated in our internal rules of the ECCC in Article 21, and in Rule 33 of the ECCC, and in the ICCPR, as the defense pointed, Article 14 of that law is well preserved. In regard to the point that the lawyer addressed about the waiver of the right to defense counsel, especially to answer to the co-investigating judges, as addressed also by the co-investigating judges, I would like to recall the times when the child person is brought to the court while the co-investigating judges issued an arrest, the provisional detention order. In such a circumstance, when the co-prosecutor did not appear during the first appearance, but we look into the procedures in the case file that the co-prosecutor can really examine the case file at any time. Having observed the case file on 19th of September 2007, I've noticed that the co-investigating judges issued an arrest warrant against the charged person and then issue provisional detention order. We also examined the record in the case file that on the 19th of September 2007, the charged person lived in his area in An Luang Wang, as he stated. So the co-investigating judges started their works from 6:30. And when having examined this report and along with the visit with the arrest of the charged person, we observed that there were doctors, medical doctors who participated in the initial appearance, and doctor knew the health condition of the charged person, and this is the report we quoted from the case file. And after he was brought to the ECCC at about 10:45, the charged person arrived to court, the ECCC, and then the charged person was introduced to the deputy principal of the defense support section, and the charged person has been explained about this legal assistant, and of course we back this information according to the report we got from the case file that the section also included this report into the case file at the same day. So these are just the brief information about the chronological order of the events of the charged person before when he was brought to the court. We also looked into what the charged person stated in the case file when he was being asked or interviewed in the adversarial hearing. The lawyer, Mr. Sun Arun, was not there during the time, and he was explained the rights of having the lawyer, but he still would like the adversarial hearing to continue without the presence of his lawyer. That's what he said and what he would like. And with the concern of the co-prosecutor in regard to the violation of his rights, we tried to explain to him, but he asserted that he would like it to continue. And We even explained to him that the adversary hearing will be decided on the possibility of the provision of detention order, and he said that the material, the document should not be read out, that he would like the adversarial hearing to go ahead. And again, these documents are submitted, and both lawyers and co-prosecutors can view the